Welcome back to this month's episode of Hearsay. I'm Anusha and I'm here with my co-host Harry. As always, this podcast is legal information, not legal advice. We're talking about Canadian constitutional law in a way that's meant to be accessible and educational. Today we're joined again by Professor Zaidi to talk about one of the most debated parts of the Charter, the Notwithstanding Clause, Section 33. A lot of people hear the Notwithstanding Clause whenever there's a major public controversy, and the conversation can get heated quickly. So today, we're going to slow it down, what the clause is, when it can be used, what it can do, and what's at stake when governments reach for it. Harry, I'll hand over to you to get us started with Professor Zaidi.
Thank you, Professor, for joining us on the podcast. For listeners who haven't taken constitutional law, what is the Notwithstanding Clause?
Well, thank you for having me here, both of you, and hello to everyone. The Notwithstanding Clause is Section 33 of the Charter of Rights and Freedoms. It is the component of the 1982 version of the Constitution Act of Canada. There is, of course, an 1867 version when Canada was first created. It's a very unique provision, what we call an override clause, and it's used selectively in certain nations like Canada, Israel, Germany. They have certain countries that have expressly stated in their own constitution the ability of legislatures, including the federal government and provincial governments, to override the constitutional rights and freedoms that their own laws could impinge on or violate. And that's usually to achieve some political purpose, some particular outcome. And it's not used every single day, and it's not used all the time. It's used sparingly. But when it is used, it's usually in the context of some kind of dispute, some kind of conflict. And that's especially true of the recent enactment of the Notwithstanding Clause issue here in Alberta with respect to back-to-school legislation.
Does Section 33 undermine judicial review, or is it an integral aspect of the doctrine of division of powers?
That's a very good question. So that requires a historical answer, number one, and number two, a little bit about administrative law. And so when we look to the history of the Charter of Rights and Freedoms, this was a negotiation, a very tough negotiation that was done during the 70s. And what that required is some consensus among the Canadian jurisdictions, the provinces and the territories, to agree upon this new version of the Constitution Act of 1982. It was signed on April 17th, 1982. I was, by the way, 10 years old. And I saw that on TV when Pierre Trudeau, Justin Trudeau's father, had signed the charter in front of at that time, Queen Elizabeth II. And it was done on a rainy day in Ottawa. And everything that's special in the world happens on a rainy day. But the idea with the Charter of Rights and Freedoms is that that particular clause, Section 33, was a very controversial one because a few provinces, including Alberta and Saskatchewan, they wanted to have that notwithstanding override provision. Otherwise, they were not going to sign on to the new charter. So that was a political issue from the very beginning. Provinces wanted to have a little bit more power and say in what the federal government is doing or what it has done. Now, the second part of the answer is the division of powers in administrative law, which is what we teach as the three branches of government: executive, legislative, and judicial. The idea with these branches of government, this comes historically from the legal philosophers like John Locke and Montesquieu and all these different philosophers from hundreds of years ago, in which they wanted to create a democratic government that is not based on the monarchy. And so they came up with this idea of the three branches. The Americans took that first, and they ran with it. We followed that. And many other countries in the world followed that too when they began doing away with the monarchy. So that doesn't mean that the monarchy plays absolutely no role. They have a symbolic meaning in today's world. But one of the things that we cherish greatly in our democracies is this separation of powers doctrine among the three branches, so that we have replaced the all-powerful absolute monarch, the king or the queen or God, and we have replaced it with essentially these three branches that is running the country. And each branch, of course, occupies its own place. They are considered to be separate but equal. But as you'll see with any issues in today's world, in the media especially, you'll see that there's often an imbalance. So the court's job as the judiciary branch is to interpret and enforce the laws that are made by the other two branches, mainly the executive and the legislative branch. Now, the executive is part of the legislative branch, so they are the ruling government. They will introduce legislation or amend it or repeal it. They can do whatever they want as long as they have the numbers to do so. The ruling government can do those things for a specific term. But the legislature itself can be consisting of opposition parties as well. They have the ruling government there, but they also have opposition members as well, whether they're MPs in Ottawa or MLAs, say, in Alberta. So it's very important to understand that historical climate of how politics works and the hierarchy of government that plays a pivotal role in our democracy. And often you'll have this big issue of the legislators, the politicians, in other words, introducing legislation which could offend principles of constitutionalism. And that is where the Charter of Rights and Freedoms comes in. It's basically our set of civil rights, which is enshrined in that charter. And when we look to the, especially the first 24 sections of the Charter of Rights and Freedoms, starting with Section 1 and reasonable limitations, all the way to, say, Section 15, which are equality rights, and all the different assortment of legal rights and freedoms that we have. It is often the case that you might have a government which is introducing legislation which they know that goes against the Charter of Rights. They want that legislation to pass. And this is kind of what happened recently in Alberta with the teacher strike starting from last year. And when there was no resolution on that, the government, the provincial government in Alberta, decided to exercise their power of Notwithstanding Clause.
How is judicial dialogue impacted by governments preemptively implementing Section 33?
That's a good question because it speaks to the effectiveness of the independence of the judiciary. One of the things that we hold very dear to our hearts is that the three branches should run smoothly, efficiently, without significant interference. But the judiciary has a job to do, which is to interpret events. And that means, for example, interpreting the enactment of a statute. Now, a statute, for those of you who don't know, is essentially a law that's passed through royal assent from a bill, which is a proposal of a law. And sometimes what happens is the judiciary branch, the judges, will interpret the making of a law or even the use of a law that's applied in a case. And they may actually find that it violates the Constitution. So it flies in the face, as we say, of the Charter of Rights and Freedoms. And they may actually, shoot down that particular law in a sense that it's considered to be invalid because it's violating constitutional rights and freedoms. That is a power to interpret events and cases and statutes, even though it was introduced by democratically elected people, which is our politicians. But politicians, despite them having powers democratically, they can't just do whatever they want. They have to operate within the boundaries of the rule of law. And that's where our courts hold the legislatures, both federal and provincial governments and municipal governments, to a very high standard that they must comply with the Charter of Rights and Freedoms, if doing so would be unreasonable.
What was the historical purpose of Section 33? And how is it relevant to its current use, whether that be in Quebec or Alberta?
Yeah, it's a good question. And as I mentioned, when the Charter of Rights first began, in the world today, we don't have too many countries that actually have introduced an override provision, because they operate on the separation of powers doctrine. They have this ability to have a legislature. Let's say in the U.S. you have a Congress, and then you have the President, and then the Senate. The House of Representatives and Senate and President can get together and basically say, we are not going to follow what the courts are ruling in this particular matter. Rather, we are introducing legislation which is designed to achieve some goal. In today's world, with Donald Trump kind of reorganizing Congress and especially immigration laws, there's a lot of that going on where big chunks of legislation are being repealed, even though people are challenging the federal government for changing these provisions as being unconstitutional. And recently, the U.S. Supreme Court recently held against many of the tariffs imposed by the Trump administration. And so that kind of shows you that judges whom are usually appointed to the bench by the president, they can still go against the same president, even though they were chosen by him or his predecessors from the past. And they may share the same political views, but as judges, they have a job to do, which is to interpret the laws and render judgment accordingly. That puts pressure on the judiciary to decide on cases which may be unpopular with the government. Often it is, because the governments can argue that, look, we were elected by the people to introduce these types of laws for immigration, for ordering these teachers to go back to school. Recently in Alberta, they've dealt with legislation about children's rights, and especially with the changing genders and testing children who are trying to establish more gender-neutral identity. And so when we're dealing with these very, very sensitive legal issues, often the courts are called in to interpret, analyze, and then make decisions. Sometimes that goes right in the face of the government and it opposes what they did. That's where the legal battle begins, and then it's not a showdown, but it's a very interesting question to answer. Will the legislation survive the use of the override clause, or will it be shot down and be ineffective altogether?
Interesting. My question is, if the legislator can override charter rights at will, does that mean that our rights are only protected to the extent of government discretion and allowance?
No, not necessarily, because the Constitution itself is, under Section 52 of the Charter, is the document that is the supreme law of this land. And that supremacy clause, as we call it, enables the Constitution to kind of supersede everything that comes before it. Like I said, we replaced a king and queen with our Constitution as the supreme law of Canada. So a court and the legislatures have to give due respect to the Constitution And if there is a finding by the judges in the judicial branch that the legislation is against the Charter, it violates it in some particular way, for example, freedom of assembly, freedom of speech, freedom of religion. It could be any of these kinds of protections in which they want to, defend against government actions which are not designed to destroy the Constitution, but to merely challenge it because of certain objectives that need to be achieved. In the case of Alberta, they wanted the teachers to go back to work in the public schools, and so they used that Notwithstanding Clause to essentially require the imposition of a collective bargaining agreement with the teachers, and to require them to go back to school, back to work. And even though their rights and freedoms were violated in terms of having them being forced back to work. Now, protesting in this country is perfectly legal. It is something that is in the boundaries of the Constitution of Canada. The only thing that's illegal is that, there's some kind of violent protest or violent upheaval of some kind that creates problems of criminality. But having peaceful assembly, freedom of assembly, is one of our constitutional rights. We have the right to protest, and that includes jobs, anything to do with employment. But because it covers such a large sector, so many families and kids and families that are even moving into the province are affected by education. Education is a broad issue, and it has huge ramifications and impacts. So because of that, the Alberta government decided to introduce the Back to School Act to force the teachers back to the table and impose new conditions and not to strike until 2028. So there's all kinds of provisions that come within the package of that legislation. But that legislation used Section 33 to achieve the government's goal of forcing the teachers back to work, and not continuing the protest long after back in October when they first started striking. So it's one of those things that there's a balance between constitutional rights, freedoms, and government objectives and actions to send people back to work so that schools can be functioning once again.
Just off that, Professor, then how can governments be held accountable so that they don't just use Section 33 every time they feel confronted by the public or the judiciary?
Yeah, that's a good question. And the answer is essentially that they don't want lawsuits on their hand for every single action or announcement they make, which could violate the Constitution. And we're talking about either the Constitution Act of 1867, which lists the division of powers, Section 91 for federal, Section 92 for provincial, or it could be the 1982 version of the Constitution Act, in which the first 34 sections are Charter of Rights and Freedoms. So it becomes one of those very tough situations where the government has to be very careful in terms of introducing any kind of legislation or regulations. And when they amend the legislation or they repeal it, they have to keep an eye on the Constitution at all times, because it is the supreme law of the land. And it can invite all kinds of actions against the provincial government if they do these kind of things. So they have to be held accountable under the rule of law through the courts. So lawsuits, there could be an awarding of damages or any kind of remedies that are granted by a court. It doesn't have to be money. It could be in the form of exercise of rights. There's all kinds of remedies out there available to unions, like teachers, for example, where it could be found that what happened in their situation where they were forced back to work could have been a major violation of the Charter of Rights and Freedoms. So that's a determination for the courts to make. But at the same time, they respect legislative intent and the will of the legislatures, the democratic will that the people who, like us, we voted for these people to go to the legislature and, do these kind of things. The question remains, though, for something so specific and unique like notwithstanding clauses, which are not used very often, did we send our political representatives to the legislature to do those kind of things? Because we may be on the teacher side, just as a society. We might be with a particular group who is fighting for their recognition of, say, identity rights, and they want to challenge the government for what legislation they've introduced. So there's a balancing act between democratic will and the protection of the constitutional rights and freedoms.
Professor, could you expand on the remedy of exercise of right that the judiciary may grant?
Yeah, so the exercise of right is essentially, depends on the context of that particular situation. In the case of teachers, for example, they're seeking higher wages. They're seeking better pay and better conditions, especially work conditions, where you have these large classrooms sizes and a very, very, kind of a difficult budget to work with, because it affects the number of resources they can use in schools, both the administrative and teaching staff. So the question then becomes, if they're forced back to work and nothing really changes because of all of those issues, then the question is, do the teachers have some exercise of right for the legal remedies that's offered by the Charter of Rights? And when you look at Section 24, that's known as the remedial clause. That allows courts to grant remedies against governments or even against, the teachers' union. It can go either way. But the remedial clause is in the Constitution for a good reason, because, it offers some kind of compensation, some recognition of rights that were previously unrecognized or just not enforced. So it's one of those things that it's up to a court of, as we say, competent jurisdiction. Like, say, a court in Alberta can, you have, of course, Court of King's Bench, you have Court of Justice, which we used to call provincial court. They can grant these types of remedies, especially King's Bench, because they deal with larger issues, with more money, more to gain or lose in that particular case. So courts are in that independent judiciary position for a reason. They are insulated from political interference, so they can make these decisions, like awarding damages or remedies to people who are impacted by the Charter in some way. And they can hold the government accountable for their actions, even though they wanted to send the teachers back to school and not delay the year for students so they can graduate and move on to the next grade or whatnot, just streamline the business. So when we order people back to work, or when we change specific or allow laws to change, it might be at the adverse impact that is realized by society. It might be greater than we think. So the damage might be more far-reaching than we think. And so that's the reason why we have the remedial clause in place. And the exercise of right is a part of that.
Perfect. Professor, is it true that Section 33 is only applied to legislation for a couple of years before it has to be reapplied? Please explain the purpose of this rules.
Usually up to 5 years. It depends on the situation, but there is some grace period in which that will arise, because courts have to sort these issues out if there are litigants filing claims. And it allows the government possibly to amend their own legislation and get out of this mess that they created. Not something that was deliberate in the beginning, but they recognized and underestimated how difficult this legislation was when they drafted it. Now, it's interesting when the legislature drafts legislation. I mean, the lawyers do that job, but sometimes they are looking to serve political interests or outcomes, objectives that is a little bit too far-reaching for people who want to be protected by the Constitution. And for that reason, we allow legislatures to go through the reading stages in which they can amend legislation, they can change it, they can repeal it, start all over again, have live debates. This is why we research our Hansard transcripts, just to see what the politicians were saying at the time of question period. And it's not just yelling and screaming like they normally do. It's also, actually determining the legislative intent, that if the government was introducing Back to School Act, why did they do that? We know generally why, but what is contained in the provisions therein. And so that time period in which, it could be a few years, up to 5 years usually, that operation of the Notwithstanding Clause has to be done carefully. Otherwise, it's going to create instability in government, and nothing will get done. It will be an effective freeze on the democratic process, and that affects a lot of bills and a lot of soon-to-be enacted laws, which have to be then enforced. So everything begins with a proposed bill. It goes through the reading stages, debates, votes, committees, all of these before, if it's possible, it can receive royal assent, and then everyone's happy with the bill to become a law, or what we call an act. And under the act are regulations, that's subordinate legislation, and the regulations refer to the enforcement tools of the law, of the statutes. So you have an act and its regulations, and that whole process requires time. And if we don't give enough time, then the legislatures can't undo what they did. They won't be able to change or amend or just kind of tailor the legislation so that it does not violate the Constitution. That's the key thing.
Professor, are there any amendments, in your view, which can make Section 33 less controversial and more applicable as part of legislation in general?
If I knew that answer, I'd be the Minister of Justice right now. But it's a very good question you're asking, and so many people have recommended different changes. But what's interesting is that, again, going back to what I said, that Canada is one of the few countries in the world to have this Notwithstanding Clause. Okay, Israel has it, Germany has it, certain countries have it. I believe New Zealand has it as well. So when you're looking at these very few jurisdictions in the world, these countries that have Notwithstanding Clause, I think a more important question is, would the other countries of the world adopt our system? Because it's not used very often in the world. And there's talk in the United States about adopting a similar Notwithstanding override clause as Section 33. On the other hand, people argue that that issue is taken care of as it is. And so with the three branches of government, separation of powers doctrine, and the checks and balances that occur between them, that function is already being played out. But do we need a more explicit provision to allow governments to do what they want without constantly deferring to the Constitution, not realizing, of course, that the Constitution is the supreme law of this land? That is the number one document that should be enforced, but not at the expense of people or governments.
Okay, Professor Zaidi, thank you so much for walking us through what Section 33 is and what it isn't. It's one of those topics that can get reduced to slogans, but today's conversation gave it a real structure. To our listeners, this has been legal information, not legal advice. If you enjoyed the episode, follow this show and share it with a friend. Thanks again, Professor Zaidi.
Thank you. Merci beaucoup.